Welcome to the MyLaw CLE presentation. During today's presentation, you may access the course materials from the handout section located on your screen. Attendees seeking credit for this presentation, pay careful attention to the screen. A pop-up box will be displayed at various times during the presentation. You will need to click Confirm on the pop-up each time it appears to qualify for CLE credit. In order to receive CLE credit, you must also click on the link that will appear at the end of this presentation to initiate the certificate process.
Hello everyone, and thank you for joining. I am Wendy Fischman, a partner in the Employment and Human Resources practice and the COVID-19 task force of the Potomac Law Group. Just a quick note before we start. My partner Mamaysky, who will be presenting with me, and I will not be using PowerPoint slides for today's course. Especially in this age of social distancing, we think that it's a nice change for us to connect a little bit more personally. But after the session, we will make our notes available in a handout for you to take with you. The coronavirus pandemic has affected businesses in ways that most people who are alive today could never have imagined a few months ago. Mandatory closures and stay-at-home orders have caused employers all over the country to have to make some really hard decisions, resulting in a historic number of furloughs and layoffs. But today, we are going to focus on the glimmer of light at the end of the tunnel. Although fraught with its own complications, many employers are beginning to plan for, or may already be in the midst of, reopening. And so many employers are thinking about rehiring laid-off employees, reinstating furloughed employees, or even hiring new employees. Now, just as the initial furlough and layoff decisions came with a whirlwind of legal considerations, so too will rehiring and reinstating workers. I'm first going to talk through with you some of the incentives to rehire that may be driving employers' hiring decisions. Then I'll discuss various considerations to keep in mind as employers embark on rehiring. That includes multiple potential pitfalls in the process, and most importantly, how to avoid those pitfalls. Before we begin, I'd like to just take a minute to go over some terminology just to be sure that we're on the same page. In different states and in different industries, these terms can sometimes have different meanings, and so I'll talk with you about what I mean when I use them today. First, what is a furlough? When I use the term furlough, I mean a temporary period of mandatory unpaid leave. The employee remains employed, but is not performing any services and is not earning any compensation. Partial furloughs are also possible, but that's not going to be a focus of today's discussion. Second, what is a layoff? When I talk about layoffs, I mean a permanent separation of one or more employees from the business. And used this way, multiple layoffs could also be called a reduction in force or a RIF, and I might use those terms interchangeably. So with that out of the way, let's dig in. Now, it feels like we just went through this very painful process of implementing furloughs and RIFs. Why are we talking about reversing them already? Well, employers have a lot of incentives to begin rehiring and reinstating employees now. Some of their motivations to rehire include what I already alluded to, which is that states are reopening. And as businesses reopen, they need to hire back people to staff their shops. There also have been the emergence of new funding sources. States, counties, and other grant programs have infused funds into businesses that may enable business owners to hire back employees sooner than they might have originally expected. One of the biggest of these programs is the Federal Paycheck Protection Program. It's a massive federal program that came out of the CARES Act, which provides low-interest loans to small businesses to help them keep their businesses afloat, and most importantly, to keep their workers employed during this crisis. The loans are great. They're at a low interest rate, they've got a 6-month deferment period, and they're payable in 2 years, those are great terms for any business owner, small business owners in particular, but their most attractive feature is that they offer the potential for loan forgiveness, which means that the loan can be turned into a grant if the business follows certain guidelines. The first is that the loan proceeds may only be used for certain purposes. The first of those is payroll costs. It also may be used for mortgage interest payments, rent, utility payments, interest payments, and for refinancing certain types of small business administration loans. However, 75% of the money has to be used for eligible payroll expenses in order for the borrower to get loan forgiveness. Now, that loan forgiveness can also be reduced in a couple of different ways. If the borrower reduces the number of full-time equivalent employees during the 8-week period of the loan, and that's based on a formula that compares the average number of full-time equivalent employees during the 8-week loan period as compared to the average number of full-time equivalent employees during a comparison period. And the Act offers two different options for that, and it's the borrower's choice as to which is favorable. If that formula suggests that the borrower has reduced the number of full-time equivalent employees during the 8-week period of the loan forgiveness can be reduced. Second, if during that same 8-week loan period, the borrower reduces the salary or wages of any employee who earn less than $100,000 on an annualized basis in 2019, if they reduce those employees' wages or salaries by more than 25% as compared with the wages during the last completed quarter prior to the loan, that also will reduce loan forgiveness. Now, there's another provision of the PPP that says that employers can earn back loan forgiveness if they bring back an equivalent number of full-time equivalent employees as those who were laid off or furloughed between February 15th and April 26th of this year, and if they do so by June 30th. Now note that they don't have to be the same employees, they're full-time equivalent employees. But if the employer reduced both headcount and wages, both would have to be restored by June 30th. So there's been a lot of talk about this June 30th deadline and a lot of questions. Unfortunately, there aren't a lot of great answers yet. We are still waiting for more guidance from the government on a lot of these points. So for example, a question a lot of people are asking is, what about layoffs and furloughs that occur after April 26th? The answer is we really don't know. There has just been no guidance on this yet, but we're hoping that there will be soon. Can an employer bring back employees at the end of June, let's say, right before the 30th, and then lay them off again in the first week of July? Well, there's no specific guidance on that, but commentators pretty much agree that you probably can't do that. And as a practical matter, it really would be very hard for any employer to meet the requirements of using 75% of the loan proceeds for payroll purposes if the employer waits until June 30th or close to that deadline to rehire employees who were laid off or furloughed before April 26th. Now, again, we're hoping that the government will issue some further guidance, and I've included in the materials that you'll receive at the end of the program a link to the Treasury Department's website where they have FAQs. They update those on a regular basis. I've been checking it pretty much every day, and if this is a topic that interests you, I would encourage you to do the same. So we've established a number of reasons why employers may want to restore their staffing to previous levels. But what if employees don't want to return? Now you might be asking, why wouldn't employees come back? The economy is terrible. Who wouldn't want to come back? But there are lots of reasons. Employees could have found new jobs, or they might be worried about COVID-19 exposure. But the reason we keep hearing about in the press is that employees don't want to return because they're actually earning more on unemployment than they can earn at work. And that is true in certain cases. But it also is a misnomer. The main reason is that employees who reject offers of reemployment may forfeit their right to continue to receive unemployment benefits. So they don't really get to make that choice. Also, the reason that many employees now are earning more on unemployment than they did at their jobs is because the federal government has been kicking in an additional $600 that gets added to employees' regular unemployment benefits that they get from their states. That $600 payment is going to go away after July 31st unless Congress extends it. Now, I'll also tell you some good news for employers who are PPP borrowers. According to government guidance, if an employer offers to rehire a previously laid off employee for the same salary and the same number of hours as the employee had before, and the employee declines, that employee is going to get excluded from calculations of full-time equivalent employees for loan forgiveness purposes. So at least the employer won't get dinged for that. Now, of course, despite all of the many reasons that employers may be thinking about rehiring right now, there are going to be a lot of employers out there that simply are not in a position to begin restoring staffing levels yet. So let's talk for a moment about some considerations for employers in that position. For many employers, business needs have changed, and it could be that they earlier did furloughs, but now are realizing that they have to separate all or some of those employees permanently. What are the considerations for those employers? Well, number one, it could affect their loan forgiveness under the PPP, as we've been discussing. But also, the employer should consider whether it might be legally obligated to return the employee to work. To make that determination, employers should be checking their furlough letters. Make sure that they didn't inadvertently promise a return to employment, which may be binding. So how could that happen? Generally, work in the United States is at will. That means that either the employer or the employee may terminate employment at any time. However, an employer can destroy the presumption of at-will employment if they promise employment for any particular period of time or under any particular circumstances. So if the furlough letter says something to the following effect, maybe it says, you're being furloughed for no more than 6 months, at which point you will be returned to work. Or alternatively, maybe it says, you're furloughed effective immediately. Your return to work date is, I don't know, September 20th or whatever. If the furlough letter contains that kind of language, you should check to see whether it also contains a disclaimer to the effect of, this letter is not a contract or guarantee of employment. Your employment remains at will. That type of savings language could save the employer from having to rehire that employee. If the letter does seem to promise a return to employment without a suitable disclaimer to preserve that at-will presumption, then you will need to determine whether the employee must be brought back to work, even if it's for a limited period of time, to reinstate their at-will status, at which point a termination can occur. Another consideration is whether these employees who had previously been furloughed and are now going to get laid off, whether they're entitled to severance. So again, in the United States, employees generally don't have a legal right to severance unless the employer has established some right to severance by either contract or policy. And by policy, that could also be a pattern and practice of providing severance in like circumstances that creates a de facto policy. So employers should be checking their contracts, their severance plans for unionized workers, collective bargaining agreements, and they should figure out, is there a severance entitlement? Even in the absence of some sort of contractual or de facto plan entitlement to severance, an employer should consider whether they provided severance to other similarly situated employees who were laid off previously. So many employers conducted layoffs at the beginning of this crisis and at the same time furloughed other employees fully intending to return them to work, only to determine now that they actually need to lay off the furloughed employers as well. In that situation, they should look at that first group of employees who was laid off initially. We're going to call them Group A. And the group of people that has been furloughed and they're now considering for layoff will be Group B. If the employer offered severance benefits to Group A, the employer might want to think about extending similar benefits to employees in Group B. Now, this may particularly be true if the individuals who make up Group A and Group B are comprised largely of employees in different demographics. So let's look at an example of that. If in Group A, the employer chose maybe a last in, first out approach to layoffs in their first round of layoffs, then Group A may have included a lot of younger employees. Those employees received severance. If Group B now is digging deeper and including employees who are more senior, those more senior employees might also be older. If those employees are denied severance when their younger counterparts receive severance, the employer may create a perception of discrimination. So we need to be careful about this. Now, I'll give you a quick note also if the employer does decide to provide severance benefits to both groups A and B. For purposes of the Older Workers Benefit Protection Act, that's the act that requires employers to provide either 21 or 45 days to an employee to consider and 7 days to rescind acceptance of a release in exchange for severance, then Group A and Group B might be considered to be part of the same employment termination program. In that case, the disclosure form, that's that document at the end of the severance agreement that contains the job titles and the ages of all of the employees who were considered and selected for the layoff, would have to include both Group A and Group B employees. Just something to keep in mind. Now let's shift to employers who are actually prepared to begin restoring staffing levels. They have the option of returning furloughed employees to work, rehiring employees who were laid off, or hiring new workers. And we're going to talk about each of those scenarios. So first, restoring furloughed employees. This is pretty simple. Generally, you just notify those employees of their return date. One thing to keep in mind there is that exempt employees should probably start at the beginning of a work week. If they're going to be paid for that work week, you may as well get the benefit of their services. And for all employees, you should look at and be prepared to reactivate health benefits if the employer's plan required employees to shift to COBRA during the furlough. It's not always the case, but it's plan dependent. Finally, employers should be thinking about whether those employees went off to work for another employee while they were furloughed. If so, employers should consider having them sign the same type of certification that all new employees sign, saying that they haven't taken any confidential information from the other employer, they're not going to use any confidential information obtained from that other employer after returning to work, and that they're not going to be violating any contractual obligations to the other employer by returning to work with the original employer. So what about employers who are rehiring laid off employees? There are lots of advantages to that scenario, particularly if all the previously laid off employees are returned. That's pretty safe from a liability perspective. It's great. These employees have less of a learning curve because they're just going back to their old jobs. Maybe a morale boost to everybody to bring people back together. But there are a couple things to keep in mind. First is these people were separated, so you need to complete a whole new onboarding process for them. You should keep in mind, though, that even though you're re-onboarding them, they may retain seniority for purposes of certain benefits and under certain leave laws, so you'll want to look into that. There are significant risks if the employer picks and chooses which employees to rehire, and I'm going to go over in a minute how to mitigate those risks. But we'll move on first to the scenario of hiring new employees. There are a lot of reasons why employers might choose to do that, even if they have their own employees that they've previously laid off. It may be that the employees who were laid off were selected because they weren't the strongest performers. In that case, the employer might not want to bring them back. Also, the economic conditions that have turned our whole world upside down and created this whole mess may also be causing employers to have to revisit their business models. They might now need employees for different roles and different skill sets. So what kind of problems might an employer encounter if they hire new employees instead of rehiring people that they previously laid off? Well, an employee who was laid off and not invited back may start to question if the reason they were given for their departure was legitimate, or if maybe it was a pretext for discrimination or retaliation or some other form of wrongful termination. So a key thing for employers to keep in mind here is they should be thinking about the demographic makeup of both the employees who were laid off and of the employees who are hired back following the shutdown. Employers also should be thinking about following their internal policies. Don't forget about those. When backfilling positions, employers should be looking at policies that address rehiring after layoffs and also those employee separation letters to assess whether the employers have to give any sort of preference to its previously laid off employees. And along similar lines, they should be looking at any promises that were made during the termination process, similar to what we discussed in the furlough process. Not only should they be looking at written communications, but they should have conversations with the managers who conducted termination discussions during those earlier furloughs and layoffs to find out whether those employees may have been promised things about being returned to employment after the crisis or once the office reopens or conditions improve, because if so, those promises could entitle those employees to reemployment. All right, so we've talked about a lot of risks, and along the way I've been trying to give you some ideas about how to mitigate those risks, but I'd like to put a finer point on it. Let's talk now about some things employers can do to try to minimize the legal risks when they're making decisions about hiring and about rehiring. So first, as I said, before rehiring, employers should be reviewing layoff and recall policies, severance plans, separation agreements, furlough letters, any correspondence relating to those earlier furloughs and layoffs, and speaking with the managers who conducted those meetings to assess whether employees may have been promised reemployment or hiring priority, or whether those prior communications otherwise create any sort of limits on the employer's flexibility during the hiring process. They also should be reviewing recruiting and hiring policies and make sure that they are complying with them. If there is no policy in place, employers should consider creating one. This is to ensure that there is fairness and a lack of discrimination or even a perception of discrimination in that process. These policies should emphasize objective, measurable, and job-connected criteria, as well as a process for ensuring and monitoring compliance. Now, when deciding which previously laid off employees should be selected for rehire, employers may be tempted to focus on past performance. That makes sense. They have that track record. But they should be focusing on objective criteria such as documented performance reviews, skills-related needs, seniority, and other justifiable factors. If they're relying on past performance reviews, they should be focusing on documented objective considerations. So for example, it's better to look at numerical rankings than the narrative descriptions that are contained in those performance evaluations. Performance metrics, if the person was in sales, look at their sales numbers or other targets and how they achieved against those targets. Also, if they're going to be looking at narratives, they should be looking for specific examples of strong or weak performance. They should be avoiding relying on subjective feedback or subjective impressions of employees' past performance or their overall fit. That is often a gateway to discriminatory hiring decisions. Now, finally, in addition to taking steps to prevent overt or implicit bias from influencing rehiring and hiring decisions, employers should also be assessing whether selections, even when made under neutral criteria, may disproportionately impact certain cohorts of employees. So for example, if an employer's rehiring decisions are based solely on past salary, which is a neutral characteristic, it's objective, so that's good, but if those with the lowest salaries are selected for rehire, it may have an adverse impact on older workers because older workers are likely to have more experience and thus they may command a higher salary. So what should the employer do in that situation? Well, they can offer to rehire the strongest candidates, let people know what the salary will be, and allow those who are selected to decide whether they want to accept the lower compensation amount. That's a much fairer way to approach that. So hopefully these tips will help employers as they embark on the next loop of this crazy roller coaster that we're all on, which is rehiring after furloughs and layoffs. Now I'll turn it over to Isaac.
Okay, thank you very much, Wendy. So just very briefly, my name is Isaac Mamaysky. I'm also a partner in the Employment and Human Resources practice of Potomac Law Group. And it's a pleasure. I was going to say it's a pleasure to be with you today, but a pleasure to be with you by video today in our new normal. So with that, it's amazing to think how quickly the world is changing. Back in March, the governor of Ohio made national headlines by telling employers across the state that they should be taking their employees' temperatures every day before work. Some saw this as a radical measure. You fast forward a few weeks, and we are now seeing headlines such as temperature checks, right? The new normal. A number of states now require employees to conduct temperature checks, and many others strongly recommend it and require it in particular industries. So let's think about the big picture of where we are right now. So the White House and CDC recently issued Opening Up America Again guidelines. New York's Governor Cuomo, it's my home state, New York's Governor Cuomo issued the Unpause New York plan. And many states are now reopening, and they're grappling with the implications of reopening and what this means for business. So this means that employers are opening their doors in a really very interesting, very unique time. They are opening up while COVID is still a significant risk to both their employees and their clients or their customers. So recognizing this, employers are crafting return to work plans with various risk mitigation strategies. The plans differ, but depending on the industry and depending on the employer, but the underlying goal is nearly identical across industries. And that is to protect employees and customers from infection while also protecting businesses from liability. Now, obviously, risk mitigation begins with a safe environment for both employees and customers. The starting point is following industry best practices, having highly trained employees, and making sure that customers know and follow all relevant policies of the employer. Of course, employers also need to comply with all relevant guidance from government agencies such as the CDC, OSHA, the EEOC. But in general, this is sort of what comprises the return to work plans. Now, all of this planning means that both employees and customers will be returning to somewhat different business settings than the ones which closed a number of weeks ago. Employees should expect, as I've already mentioned, temperature screenings before work. We should expect to see physical safety barriers. Many of us already have. If you're going to supermarkets and not relying on, Fresh Direct, you've seen the plastic shields between, cashiers and customers. We'll see more of that type of thing. We will see limits on the number of people allowed in meetings. We will see bans on shaking hands. We will see mandatory hand washing and mask wearing and various other safety measures. So now, as our clients are planning their return to work processes, their return to work plans, they've been asking us two key questions. Number one, will there be legislation limiting COVID liability? And number two, can we use COVID liability waivers in this, quote unquote, new normal in which businesses are operating? Now, obviously, the government will answer the first question, and there's debate back and forth, and we certainly might see legislation limiting COVID-related liability. For this presentation, we're going to focus on the second question of should companies implement waivers for their employees and their customers. So before getting there, let's start with a more basic question. What are waivers? So many people use the term waiver thinking that it's one particular provision of a larger agreement. I mean, look, as lawyers, we've all seen an otherwise simple and straightforward agreement that includes a long waiver paragraph, often in all caps. It's written generally in arcane language, and it's very challenging to understand, and it attempts to disclaim every possible liability under the sun, regardless of the industry. So look, that is probably not an effective waiver. Perhaps it was an effective waiver when it was first drafted, in 1937 or whatever, but today it is probably less effective than a business would like it to be. So here's the thing. When you have a well-written agreement defining your relationship with your customers, with your clients, that entire agreement is your waiver. In other words, a waiver is really a series of contractual provisions that each have their own legal impact. So let me explain what these provisions are. Let me explain what these provisions do. By the way, I should mention, in many ways, the law of waivers is really a survey of the basic principles of contract law. So to those of you who were not such fans of contracts class in law school, I apologize in advance if my presentation is about to bring back bad memories for you. And I guess to those of you who enjoyed contracts like myself, then maybe you will, this will bring back positive memories for you. Anyway, as I said, the term waiver has a twofold meaning. It is sometimes used to refer to a specific contractual clause which disclaims liability for various events. I suggest that the more useful approach is a larger waiver agreement that consists of a series of contractual provisions that work together to mitigate certain risks of liability. Now, to be sure, the agreement includes the actual waiver clause, but it also includes a number of other additional protective provisions which limit your liability through other legal mechanisms, and we will talk about these things. Now, I should mention, there is a really excellent book called Waivers and Releases of Liability by Dois and Mary Cotton. They are now on the 10th edition of this book. Their text significantly influences my understanding of the law of waivers. I'll tell you, this is not a prop for this presentation. I have their book on my desk because we've been getting so many waiver questions. I've been referring to it constantly. And if I knew the authors, I would call them to thank them, but I don't. So maybe I'll settle for a good review on Amazon. But I will tell you, it'll be the best $70 you've ever spent on Amazon if you are dealing with waivers for your clients. It's a very thorough book. So anyway, in that book, the authors argue that the more appropriate name for a properly drafted waiver agreement should be the assumption of risk, waiver of liability, and indemnification agreement. Now, as their proposed name suggests, the primary provisions of a complete waiver agreement are the namesakes, meaning the assumption of risk clause, the waiver of liability clause, and the indemnification clause. There is a fourth primary provision that I also think is very important, and that is the agreement to comply with essential policies, and we will discuss all of these. Then, of course, there are a number of secondary clauses of which you should also be aware. There's the covenant not to sue, the severability clause, the choice of law clause, and the integration clause. And again, we will talk about all of them right now. So let's start with this. We will consider the intended impact of these clauses. What are they supposed to do? And I will explain to you the relative strength of these clauses in your waiver agreements. Now, let's begin with the primary provisions. So the strongest waiver provision is the assumption of risk clause. This explains the inherent risks which cannot be mitigated by a business's care. To give a very simple example, some of the inherent risks of attending a summer camp might include sustaining a sports injury, falling off a horse, getting a tick bite, or a sudden change in weather that causes some kind of injury, right? The assumption of risk clause, what it is intended to do is to disclose these risks that cannot be controlled by the care of the business, that nothing the business does will prevent an injury on the basketball court. Obviously, this is assuming it's a well-maintained court. No matter how pristine it is, no matter how every little pebble is removed, there is still this inherent risk of someone falling and hurting themselves while playing basketball, and nothing the company does can reduce that risk. Next, A slightly weaker provision of your waiver agreement is the actual quote unquote waiver clause. The waiver clause, so again, the inherent risk clause, it's intended to prevent liability for things that are not the business's fault. By contrast, the waiver clause is intended to prevent liability from injuries that stem from a business's ordinary negligence. So in other words, even if a business did act negligently, the waiver clause is intended to limit liability. Now, courts will sometimes, perhaps often, accept well-drafted waivers of ordinary negligence. They generally do not allow any waiver beyond ordinary negligence. Gross negligence, recklessness, intentional conduct, you cannot waive liability for those things. Next, we have the indemnification clause. So what is this clause? Basically, the indemnifying party agrees to reimburse the indemnified party for any loss to others caused by the indemnifying party and any loss incurred by the indemnifying party. So let's put this in plain English. One party says to the other one the following. One party says, I will reimburse you if I do something that causes someone else to sue you. Further, I will also reimburse you if an injury to myself causes you to have a loss. Now, here's the thing. Courts typically uphold these between sophisticated businesses. They are very reluctant to uphold them between an individual and a business. So this is why I say it is the weakest of the primary provisions. And the final primary provision of a waiver agreement is the agreement to comply with essential policies, to follow essential rules. And this helps establish a contributory negligence defense if a party is injured because of that party's own failure to comply with a rule that they knew about. Now, briefly, waivers also have a number of secondary provisions, and these play an important role in the agreements. The first is the choice of law clause. So, of course, states have different approaches to the law of waivers. This clause allows you to pick a relevant state that has favorable waiver law to the extent that multiple states sort of touch your business. By the way, I should mention that book I mentioned above, and there's a link to it in the materials that Wendy and I have prepared for this session. It actually has a state-by-state chart that shows you how various states approach waiver law, and it also has like a chapter. Those authors should really pay me for the pitch that I'm giving to this book, but it's a great book, and they're not paying me. I don't even know them. Anyway. They have a chapter breakdown, state by state, of waiver law in each state. So you can really pick the law that would be best. Okay, next we have the severability provision, which ensures that if one clause of the contract is unenforceable, the rest of the contract is still enforceable. The related integration clause, that prevents a party from trying to rely on past communications in the current contract. In other words, that way they can't say, well, I was told such and such by email, and I was relying on that promise. The integration clause says this agreement is our complete agreement. And finally, we have the covenant not to sue. The covenant not to sue is slightly different than the actual waiver clause. The waiver clause eliminates the cause of action. The covenant not to sue says basically, look, there may be a cause of action, but I agree not to sue you for it regardless. Okay, with that overview of what waivers are, let's now consider waivers in two separate contexts. First, between a business and its employees, and second, between a business and its customers. So let's begin with the employment relationship, and let's ask ourselves, is there a new role for waivers to play in the employment context? Now, look, I should tell you, we have been getting this question a lot from our clients. Thus the reason, as I said, I have this book on my desk, because we've been getting so many waiver questions. My partner, Mark Papadopoulos, and I, we actually wrote an article, which will be coming out in Law 360 in a few days, about this very topic. I mention this because many of the concepts we're discussing are the result of Mark's research and Mark's insights and Mark's analysis. And I just want to mention that and sort of give him credit. And this is especially true in terms of waivers in the employment context. Okay, I want to begin with an important ethical consideration when we think about waivers in employment, and that is the following. Last I read, we have reached roughly 15% unemployment, with about 20 million jobs lost in April. Now more than ever, many employees will sign just about anything to get a job. But even in normal times, even outside of this crazy pandemic, courts have always disfavored waiver agreements between employers and employees because of the unequal bargaining power between the parties. Waiver agreements in the employment context, they are generally thought to violate public policy. Waivers are further limited in the employment context because of workers' compensation statutes. So workers' compensation, they provide medical expenses, lost wages, rehabilitation costs to employees who are injured in the course and scope of their employment. These statutes generally prohibit lawsuits against the employer for all but intentional actions, with some few states allowing gross negligence suits. So this is called the workers' compensation bar, and many lawsuits are stopped by the workers' compensation bar. The one employment context where courts have upheld waivers is where employees are engaged in these quote unquote inherently risky activities. And I should note, by the way, when you think about waivers conceptually, this is also the strongest provision of any waiver, whether it's with a client, a customer, or with your employees. It's this assumption of risk concept that courts seem likely to accept an assumption of risk, an inherent risk that cannot be mitigated by the employer, based on this sort of larger principle that employers in most contexts should not be liable for things that are not their fault. If an employer did nothing wrong, in theory, they should not be held liable. So assumptions of risk are powerful. So in what industries have this applied? And we're going to come back to this, but obviously these are very uncommon industries in which none of us, I assume very few of us practice. Courts have upheld them in skydiving, horseback riding, wall climbing, physical fitness related industries. And these types of industries, they have been allowed. Now, at this point, you might be asking yourself the following question. Didn't we just say that workers' comp blocks most lawsuits against employers? We did. Didn't we also say that waivers do not prevent lawsuits for gross negligence and intentional conduct? We also said that, right? Waivers do not apply to gross negligence. They don't apply to intentional conduct. So in other words, why would an employer want a waiver? And if they're already barred by workers' compensation, what's the point? So to answer very briefly, in some situations, the workers' compensation bar does not apply. For example, in some states, certain small employers don't need to have workers' compensation coverage. Employees might be at work but not working, right? Like in certain circumstances, workers' comp wouldn't apply. And in those circumstances, a disclosure of inherent risks, an assumption of inherent risks could add some value. Now look, time will tell what this means for our new post-quarantine COVID world. Most workplaces are certainly more dangerous than they were a few months ago. Despite taking all relevant precautions, an employee still might contract COVID at work. And workers' compensation will likely bar the majority of COVID-related claims. But is there room for an assumption of risk? Is there room for a waiver? Time will tell how this plays out. Time will tell what courts will do about this. So in any event, I suggest to you that waivers are limited in the employment context and perhaps not so valuable in the employment context. So now the next question becomes whether there is a new role for waivers in a company's relationship with its clients and its customers. And it is in this context that I believe waivers have more promise. And it is in this context that we are certainly advising a number of our clients to implement waivers. So again, let's begin with the ethical question. Look, I personally don't have qualms about waivers between a business and their customers. And why is that? It's because customers are the ones with the purchasing power, so they can always choose to take their dollars elsewhere. And we will come back to this point momentarily. So from a big picture standpoint, as various states reopen, many businesses are exploring how waivers might apply in industries that have not traditionally used them. So when thinking through this question, it is certainly instructive for us to look at the businesses that have relied on waivers for years and years. So what are some examples of sort of the industries that traditionally use waivers? So think fitness centers, golf courses, community pools, summer camps, YMCAs, ski resorts, and sort of many similar businesses. You know, every gym member has had the experience of signing a waiver before being allowed past the front desk. Now, look, do most of us represent YMCAs and fitness centers and golf courses? I venture to say that we don't. But as customer-facing businesses look to stay afloat in this new world, the experience of these industries is certainly relevant, and we can draw on it. So let's think about it like this. You walk into a gym, you show your card. The card says, I've paid my dues, and it says I've signed off on the waiver agreement, therefore I can be allowed in. Think about membership-based big box retailers, right? The Costco's of the world. They already use a card for entry model, much like a typical gym. Could we be entering a future where other retailers follow suit? You know, could various service providers who already have existing client contracts add assumptions of risk and waiver language? It is certainly possible. Certainly possible. It's certainly something clients are asking about. These are certainly agreements that we are drafting. And as we move into a post-quarantine world, I think customers will begin seeing waivers in contexts where they have not seen them before. Now, look, any business thinking about adding a waiver should carefully consider some important points. First of all, waiver agreements are by no means flawless instruments. Courts tend to interpret them very narrowly. They tend to construe them against the party seeking to rely on the waiver. So waivers have, these sort of drawbacks. Now, even when drafted properly, a lengthy liability waiver might not be the best way to begin your relationship with your customers in a post-COVID, post-quarantine world, I should say. I should say a not post-COVID, post-quarantine world, because COVID is very much relevant to all of this. As I said before, customers have competing businesses vying for their attention. And this is the reason that waivers for customers don't have the same ethical considerations, because customers can simply take their business elsewhere. I will just caution that if you provide some kind of essential service and there is no alternative provider to your service, then it does raise some ethical challenges, forcing customers to sign an ironclad waiver. But if you are like most businesses and you're competing, in a large landscape of other similar businesses, I see certainly no ethical issue with that, because customers can go elsewhere. But what does this mean for our clients? This means that even though they're very risk-averse and conservative attorneys might advise them to implement waivers in the interest of caution, as a purely business consideration, our clients might not want to, because such waivers could be off-putting to customers. So now I'd like to go back to where we started. And I will conclude the discussion of waivers by saying the following: that the foundation of risk mitigation is creating a safe environment for employees and a safe environment for customers. It means complying with relevant regulations, adopting all industry best practices, having well-trained employees, having customers who know all relevant policies and follow those policies. And only once this foundation is in place, once a safe environment has been established, then perhaps a waiver is a piece of the larger puzzle. But it is the final piece, certainly not the foundation, and certainly not the starting point. So with that, let's turn to one small component of the foundation. As I mentioned at the start, employee temperature checks are becoming part of our new normal. And it's not surprising why, because everybody is nervous, everybody wants to maintain a safe workplace, and temperature checks are one concrete step that employers can take to keep their employees safe and to keep their customers safe. Certainly not a flawless step, and it has to be part of much larger efforts, but a concrete step that many employers would like to implement and many states are requiring. Now, whenever employers conduct health screenings or otherwise make decisions based on the health of their employees, the Americans with Disabilities Act becomes a key consideration. The ADA, it regulates medical examinations conducted by employers. It regulates the medical questions that employers can ask their employees. And of course, it requires reasonable accommodations to disabled individuals in the workplace. The Equal Employment Opportunity Commission has issued fairly extensive guidance. I give you guys a link to it in the materials so you can see the guidance, very straightforward, written in very clear language, to help. So it's guidance to help employers navigate ADA considerations as the employers take steps to keep COVID out of the workplace. I'd like to briefly share some of my key takeaways from the guidance with you, and perhaps you will find it useful. And as I said, the guidance is very clear, very simple language. You can certainly look at it directly for clear instructions. So number one, employers should not ask questions related to disabilities. They shouldn't ask whether an employee has a compromised immune system or a medical condition that makes the employee more susceptible to COVID-19. Employers can ask questions about symptoms of COVID to ensure that sick employees stay home, which is, of course, everybody's goal. Likewise, if an employee calls in sick, an employer can certainly ask about symptoms of COVID. I should say, if an employee calls in sick without giving details, they just say, hey, I'm staying home today, I don't feel well. In that context, the employer can certainly say, well, do you have a temperature? Do you have a cough? Whatever other screening questions they have in order to protect the rest of the workforce. However, and perhaps it's obvious, but maybe it's not, employers should not ask these questions if an employee is already working from home. If an employee is already working from home, then it's irrelevant because they haven't exposed any other employees. Next, employees can conduct temperature checks, as we discussed. They can administer COVID tests. They can conduct various types of health screenings for COVID of their employees, and they can even do this of new employees after making a conditional job offer. Now, what if an employee refuses a COVID screening? They refuse to answer questions. They say, I refuse to have my temperature taken. What can the employer do? So the employer can bar that employee from the workplace. But the EEOC tells us that if an employee refuses to be screened, the employer should begin by telling the employee that the information will be maintained in a confidential medical record. Nobody will know about it. It will be kept in strict confidence. And the EEOC suggests that if an employer says that to an employee, the employee is more likely to submit to the health check and say, fine, it's no problem. Now, on that note, any records resulting from medical screenings should be maintained in a separate medical file, not as part of the employee's personnel file, and it should be treated as a confidential medical record. Again, this point of confidentiality, it's very important, and it comes up repeatedly in these COVID questions. So if an employer sends an employee home because they have COVID symptoms, that should stay completely confidential. Employers can and should tell other employees that those employees were exposed to a coworker with COVID, but the employer should not say who that coworker is. Their name should stay out of the conversation. Of course, look, if an employer has a small workplace, a few employees, someone was sent home, obviously everyone's going to know who it is, but the EEO says even in that context, employers should not confirm. The employee's name should only be shared with those who have a need to know. And I will just add that a very important person who has a need to know is someone in management who will then interview the sick employee to determine who they have been in contact with, so they can, so the employer can warn those people and have those people self-quarantine for some period of time. Now, along the same lines, and our final point of confidentiality, if an employee is working from home because they have COVID, an employer can absolutely tell coworkers that, John Smith is working from home, but the employer should not say why. And if coworkers ask, the employer should not confirm the reason. Okay, moving on, and we are sort of nearing the end. Employers can delay the start date of an employee who has symptoms of COVID. If an employer needs an employee to start working right away, but the employee has COVID, the employer can actually withdraw the job offer to hire someone who is available to start immediately. Employers can certainly request that employees who have been exposed to a person with COVID, who have traveled to an affected area, that those employees stay out of the workplace during a quarantine period. Now, employers who send an employee home, they can certainly request a doctor's clearance prior to allowing the employee to come back. But I should just note the CDC tells employers not to require a doctor's note to validate symptoms because that discourages employees from staying home. And of course, all of our goal is for employees to stay home. And finally, employers can implement various infection control practices, which we should expect in our new workplaces. Regular hand washing, mask wearing, banning handshakes, all of these types of measures we should certainly expect. With that, I turn it over to Wendy to answer some of the questions. And while she answers, I will look at some of the others that came in.
Thanks, Isaac. So a question came in about the PPP. It says a business received a PPP loan, but the business is still shut down through state order. All of the employees are receiving unemployment benefits. The PPP only provides for payment of salary, rent, etc. over a certain period going forward. Can the borrower extend use of the funds until the employees are done with unemployment? And in this case, the unemployment payments are more than normal salary. So you've just identified a huge issue with the PPP that has a lot of people scratching their heads. The whole point of the program is to keep employees employed, but circumstances, including these government shutdown orders, have forced the complete shutdown of lots of businesses. And of course, as you've identified, the PPP requires borrowers to use those funds during the 8-week period after the loan is funded. Now, I think that has to happen, I think it's within 10 days after the loan is approved. So there's a little bit of wiggle room if you're working with your lender, with the bank, as to when they actually fund the loan. That can sometimes help with payroll periods and cycles. But other than that, the money has to be spent during that 8-week period. So if the employees can't work, employers are basically funding unemployment. They're expected to pay them for doing nothing. But that's really hard if the employees are earning more under unemployment. So you haven't missed anything. There isn't any real solution to this that I'm aware of unless Congress amends the act. But the one relief that borrowers have is that, and I mentioned this a little bit earlier, if the employer offers to reinstate the employee at the same compensation level and with the same hours that the employee was offered before, and the employee declines it because they're getting more in unemployment benefits, then at least that won't affect the PPP borrower's loan forgiveness amount with respect to the number of full-time equivalent employees, because that employee won't count. So that is, I think, sort of the interim step that the government has offered just to kind of make that a little bit easier. So Isaac, I don't know if you've had enough of a chance to read through the questions. I don't know if you want to take another question. If not, I'm happy to take one more.
Sure. I can, I can certainly take one or two of these, and I can answer one quickly, and then we'll turn it back to you. How does that sound? Okay. So here we have. I'm just conscious of time. We have one question that's a very good question about an employee who is given a start date and they don't want to come back. Can we terminate that employee? That's an excellent question. I have a detailed answer to it. I'm just afraid that the timing will not allow me to give the full answer. So I will say this in relation to that question. The key concern, and I'm being told that we can go a bit over. So if we can go a bit over, then now you're about to get your real answer. Perfect. I see the message that came in. So, all right. The employer should begin by understanding what is the reason for the request. Why is it that the employee does not want to come in on their start date? Why is the employee scared to come in? What is this? The EEOC makes clear that employers are still obligated to provide reasonable accommodations to employees with disabilities during a pandemic. So, people with chronic lung disease, with heart conditions, compromised immune systems, they are at much higher risk of complications from COVID than the general population. So if an employer determines that the reason for the request is a disability, then the question becomes whether the employee can perform the essential functions of the job from home. If it is definitely not possible, then the employer certainly does not have to provide the accommodation of working from home. But perhaps the employer can take some simple measures to provide an accommodation in the workplace that would meet the employee's needs and would make the employee much more comfortable with the prospect of coming in on their proposed start date. I should just add one final piece of this. The question was, if an employee refuses to come in, should we terminate? I always try to avoid going to termination as the initial solution. I think that the best initial solution is talk to the employee, understand the situation, understand why they don't want to come in, see if you can do something that will put them at ease. And if the answer to that is yes, then great. And if the answer is no, or if let's say they don't have a disability, let's say they just tell you, I'm afraid, COVID is a scary time, I'm afraid. If that's what an employee tells you, then I would sooner go to unpaid leave until all of this passes than going to termination. But again, every employer is in a different circumstance, and sometimes they might only have one option. So Wendy, with that, if you want to take the next one.
Okay, yeah, I'm not sure how late we're supposed to go, but I'll take another question. Somebody asked, are there any concerns about using PPP funds for severance payments? So our understanding is that severance is an appropriate payroll cost that can be used under the PPP, but there are some considerations in terms of the timing. So again, as we discussed, whatever payments are going to be made, they have to fit within that 8-week loan period. So if the employer is going to offer severance, that would be less than 8 weeks, say it's 6 weeks of severance, and it can be paid during that 8-week period, that shouldn't be a problem. And it shouldn't really matter whether it's done in installments or in a lump sum, which is the other question that often arises when we talk about severance. The general consideration under the PPP is that in order for qualifying expenses to be subject to loan forgiveness, the expenses have to be both incurred, well, I shouldn't say that. They have to be incurred and paid during the 8-week loan period. And there's some disagreement among commentators as to whether it's both incurred during the period and paid during the period, or whether amounts that are incurred during the period are subject to loan forgiveness and amounts that are paid during the period are subject to loan forgiveness. So is it the conjunctive or the what is it, disjunctive, whatever, and or. So that creates an issue if there are installment payments that would extend beyond the 8-week period. And that would seem to be a risky move. It seems that if the severance amount is going to be greater than the equivalent of 8 weeks worth of the employee's salary, that it would be better to pay it in a lump sum. But there's a caveat there. We don't know, we don't have any guidance on the question of whether the government will prorate that amount based on the employee's salary. One tip I would suggest is, if you're going to try to do that, I would be careful about how you word it in the severance offer or in the separation agreement. I wouldn't refer to it, as we often do, as this is the equivalent, you're getting a lump sum payment of X amount of dollars, and that is the equivalent of 10 weeks of salary. I wouldn't word it that way. I would just do it as a lump sum. But again, I can't say whether that would be allowable, or whether the government may, at the end, look at that amount and prorate it based on the employee's normal compensation. So those are the issues that come up when it comes to severance, or at least the questions that we've been getting from our clients. All right, so I think we've certainly reached our time. Thank you so much for spending this time with Isaac and with me. We've enjoyed delving into these issues with you, and we will provide those materials that we discussed at the end of the presentation, and we encourage you to reach out to us if you have additional questions.
Thank you so much. Thank you, Wendy, and thank you to everyone for your attention and your participation. Okay, bye-bye.
As stated during the beginning of today's presentation, the link to initiate the certificate process will be displayed momentarily. My Law CLE would like to thank you for your participation in today's presentation.